Hello, everyone, and welcome to week 11. We're very close to the end of the term, and I thank you for staying on in this unit. And I'm hoping that by now you would have had a stronger familiarity and gained broader knowledge of alternative dispute resolution. Now, because we're in week 11, you would also have noticed that on Moodle, the Have You Say survey link is already up. And I'm hoping that because you're watching this lecture video, you might be able to also find the time to actually just answer that Have You survey. There is a lot of communication coming from all the way from the Vice Chancellor down to the Dean of the School of Business and Law to really encourage students to do the Have You Say survey, because the comments and the evaluation coming from students is really important. Is really important feedback to academics and in the way that we might be able to improve the delivery of the LLB program. And so I hope you will find the time after you watch this lecture video to just spend a few minutes. I'll probably take you between 3 to 4 minutes, which is actually faster than getting a cup of coffee or even doing any other errand to do. So I'm hoping you'll find the time to do that. Okay, so having just reminded you, if you could, to please do the Have You Say survey, I'd now like to talk about in this topic special issues in practice. In particular, we're going to be focusing on mediation, and we're going to be looking at power issues, which we've somehow considered in the previous weeks, but we're going to be touching on a different aspect of power issues in relation to the role of mediators. We're going to be looking as well at the impact of having self-represented parties in mediation proceedings. And when we speak of self-represented parties, these are typically individuals who do not have any lawyer or solicitor representing them or being able to provide legal advice. We're also going to be looking at the impact of having third parties who are not really there at the negotiating table or during mediation sessions. We're looking at gender issues and questions about when it might be appropriate or not to have mediation in particular legal matters. So let's get going. And so on completing this topic, you should be able to discuss and explain the issues in relation to mediation sessions that relate to power, self-represented parties, people not at the negotiating table. We're going to be discussing shuttle processes, which I failed to mention when I made a few statements earlier, gender, as well as whether or not to decide not to mediate. Now, we've already covered part of the issue relating to power imbalance, and this was in relation, for example, to Tapuhi and Lewenberg #2, as well as in Torino and Maynard, where it would have been apparent to us that where there are instances where there is pressure that is unduly exerted by a mediator upon the parties to reach an agreement, there is the possibility that that agreement may be set aside. The court would have been prepared potentially to set aside a mediation agreement that was done with undue pressure or undue influence or perhaps even coercion on the part of a mediator. And we're going to be looking at that in just a bit more closely in a short while, although in a more brief sense. This is because we know that as far as mediation proceedings are concerned, the role of the mediator really is to facilitate a discussion and negotiations between the parties, and the mediator does not have any determinative or adjudicative role, not even an advisory role in relation to mediation proceedings. And the goal really is to really empower the parties to try to reach an agreement between themselves. And so therefore it would go against the idea of self-empowerment on the part of the parties if the mediator exerts undue pressure or even coercion upon the parties to reach an agreement. Let me just move that away. Hang on, let me just stop sharing there for a while. So because I wanted to discuss that, I didn't want you to get distracted about the cases. And so there is the danger, for example, that some mediators, because they think that the best way for them to be evaluated as good mediators is to actually be able to show that every time they mediate a mediation proceeding, there's often a high likelihood that the parties reach an agreement. And to them, that will be a scorecard that will indicate that they are effective mediators. And for example, on the part of lawyers, lawyers may say that they are very successful litigants or successful lawyers because they would have won a lot of legal cases. But perhaps on the part of mediators, they may feel that the way that they can be evaluated as being effective mediators is to be able to demonstrate that a lot of the mediation sessions that they've facilitated end up in achieving a settlement agreement between the parties. Now, the danger, of course, with this particular mindset, and I would imagine that this is true for some of the mediators, the danger there is that the mediator may exert undue pressure upon the parties to reach an agreement. And that detracts from the idea, number one, of self-empowerment, but number two, it may go against the idea that there is consent on the part of either or both parties in reaching an agreement, especially if there's really strong pressure or undue pressure coming from a mediator. And because of that, we need to be aware of that strong power on the part of the mediator, especially as we consider in a short while instances where the parties may be at a very strong disadvantage when they enter into mediation proceedings because of a number of reasons, which we will now consider. Okay, we're going to look at the National Mediator Accreditation System in a short while. But looking at power issues as well, we will notice that when a litigant, for example, or disputant comes to a mediation proceeding, especially if that disputant is unrepresented or does not have the ability to engage a counsel or a solicitor, or may have had a very passing opportunity to seek advice from a solicitor, what it actually means is that you may have a disputant who doesn't have any experience and may be unfamiliar with the process of mediation. That puts the disputant at a serious disadvantage, especially if the other party may have had an opportunity to engage counsel, seek legal advice, or have been part of a mediation process before. Especially if that party is aware of the constraints or the power, the power limitation of the part of a mediator. But for somebody who is inexperienced, somebody who is unfamiliar with mediation proceedings, may form the view that there is so much power on the part of the mediator, and that if a party, for example, if a disputant in a mediation proceeding fails to reasonably enter into a settlement with the other party, that disputant may think that that can be used in evidence against him or her, notwithstanding any statements on the part of the mediator that the proceedings are essentially confidential. So the lack of experience and unfamiliarity with the process will work against a client or a disputant. There's also the problem about the lack of legal knowledge, which we will consider in greater detail. And there will be concerns as well about questions of financial disparity, in the sense that certainly if you have a situation where one of the parties may have greater access to money or financial resources as opposed to one, there's always the concern on the part of the disputant that it may be better to get a raw deal rather than see a protracted legal process, which can be a huge drain on finances. And oftentimes, especially, for example, in family law matters, it may be possible that one of the parties not only is struggling financially, but is also emotionally handicapped, especially having just come out of a separation from the other party, and perhaps even the possibility that at that point where they've engaged in mediation, that one of those disputants may not have had access to his or her children. And so, that person would then be dealing with issues of this disadvantage in terms of money, access to finances, as well as having to be burdened by emotional issues, even by depression and so on. And so these are some of the things that are often quite common in mediation proceedings and which have impact on disputants as well as mediators. There's also the question of the possibility that there is a history or evidence of domestic violence, fear, or threat. And sometimes this evidence of domestic violence, fear, or threat may not be something that's articulated by any of the disputants, maybe out of fear or maybe out of ignorance, in the sense that one of the parties may not be aware that there are actually laws that protect an individual against domestic violence or family violence. So there'll be problems about issues of, that a disputant may end up having a bad deal, which we're going to look into in greater detail, and the belief on the part of a mediator that a disputant ought to get legal advice. So we're going to be examining these issues in greater detail in a short while. But before we get there into the details, let's just briefly go back to the requirements under the National Mediator Accreditation System. And in section 7.1, for example, there is a requirement that a mediator must conduct the mediation in a fair, equitable, and impartial way without favoritism or bias in an act or omission. So I'd like you to keep this in mind. What exactly does it mean when a mediator is expected to act in a fair, equitable, and impartial way without favoritism or bias in an act or omission? Because I'm going to provide some scenarios, and you can see how difficult it can be for a mediator to discharge this particular obligation. There's also a section in 7.4 which provides that a mediator must support participants to reach agreements freely, voluntarily, without undue influence, and on the basis of informed consent. In 7.6, a mediator must ensure, so far as practicable, that participants have had sufficient time and opportunity to access sources of advice or information necessary for their decision-making. A mediator must encourage and support negotiations that focus on the participants' respective interests, issues, and underlying needs, and must encourage participants to assess any proposed agreements accordingly and with reference to their long-term viability. And finally, a mediator should encourage participants to obtain other professional support when appropriate. So the reason why I decided to highlight these particular obligations on the part of mediators as part of the National Mediator Accreditation System guidelines is that they're, in a sense, they're more complex than they seem. And we're going to be examining some of those scenarios. So take the case, for example, where the mediator is aware or perceives that one party is getting a bad deal. Now, we know that there are some mediators who are lawyers or solicitors, so they have a legal background. And because of their legal background, they know the respective legal rights and positions of parties. They know at a minimum what a party will get if the legal matter was actually adjudicated by a court. So they have an idea. And even those involving mediators who do not have any legal background, because of their experience in constantly mediating certain disputes, they would get a sense about what the law is and how parties or disputants would typically reach an agreement. And so the question then is, what if a mediator gets a sense that a party is giving up too much of her legal rights or interests and is perhaps getting a bad deal? It might, for example, in relation to a claim on the basis of a breach of contract, perhaps the mediator gets the sense that a party should perhaps be getting X amount of money, but instead what the parties appear to contemplate is an amount that is less than what a particular party would be getting if it actually went to court. Or let's assume that the parties are about to reach an agreement whereby perhaps one of the parents is giving up much of the opportunity to take care of a child. And of course, that not only does that have an impact upon the parent and the relationship of the parent with the child, it can also have financial implications in terms of child support. And so the question then is, what should the mediator do? Should the mediator, for example, really counsel the party, one of the parties or both parties, and say, I think you need to get legal advice? Is that part of the job of a mediator? Or should a mediator say, I think you're getting a raw deal? But if that were the case, wouldn't that have, for example, wouldn't that involve, therefore, an attempt on the part of a mediator to kind of, implicitly provide advice in a mediation process? So that can be of a concern. But on the other hand, if a mediator allows what appears to be a raw deal to become a binding agreement between the parties, how would a mediator feel knowing that there was some unfairness and a sense of injustice, in the way that the parties reached an agreement? And what would it mean for the issue of self-determinism on the part of the parties? That the parties are actually, as autonomous individuals, are actually in a better position to reach an agreement. If what would be the implication in relation to self-determinism if the mediator did more in terms of trying to influence, or perhaps be more explicit in saying that hey, you might want to consider legal advice? So that's one of the problems that a mediator can feel. And the other problem, of course, is that when it comes to confidentiality, the danger there is that, as we know, the mediation proceedings are confidential. Anything said there or done is confidential and can't be used. And so therefore, there is the danger that, given the opaqueness and, in a sense, the shroud of secrecy in mediation proceedings, it is really possible that there might be issues of unfairness, not really bordering on something illegal, but questions of ethics and unfairness that may arise in relation to the behavior of a mediator. And of course, given the secrecy and confidentiality of the proceedings, a mediator will not be held accountable for his or her actions, in trying to become more interventionist in the way that the parties may try to reach an agreement. The other question, of course, is that what would the implication be if the mediator becomes more active, perhaps takes a more interventionist role in the way that the parties reach an agreement? What would that mean in relation to the obligation of a mediator to be impartial? Would a mediator be playing favorites in trying to insert himself or herself more into the process by which parties reach an agreement? There are no easy answers to these questions, but I raise these points because I'd like you to think about them. Now, and so in relation to that, what exactly should the mediator do if the mediator feels that the parties should seek legal advice? And in relation to that, what if the mediator feels that the parties are about to enter into a settlement agreement that might not be enforceable, or which might be void? For example, under the Child Support Assessment Act, common law, it is a requirement not only that the child support agreement be in writing, it's also a requirement that the parties must have sought and been given independent legal advice in relation to the child support agreement. And in the absence, in the event that there's a failure of the parties to meet the requirements of the Child Support Assessment Act, then any written agreement that they enter into, or any oral agreement that they enter into, would not be enforceable. And so what actually happens then if the mediator somehow knows that in the course of the mediation between parties, the parties are entering into an agreement that is likely going to be unenforceable? Should the mediator call the parties out, or one of the parties out, that there is something wrong with their legal agreement? And wouldn't that breach the obligation of the mediator to be impartial? And wouldn't that breach the obligation of the mediator to merely be facilitative and not provide any advice in relation to the respective legal rights of the parties, or in relation to the law? There might be instances there where the parties may, the agreement reached with the parties may become void, for example, on the basis of being uncertain. For example, the parties may say that if in the event that they have a future dispute, they will then refer it to XYZ, mediation center or something. And it turns out that center does not exist, which means therefore that there's uncertainty in one of the terms of the contract, and which under contract law would mean that the contract is void. So when the mediator has a sense that the contract is unenforceable, or it is void, or one of the parties is having a raw deal, what exactly should the mediator do? And so therefore, the point there is that there are no easy answers. There's often a tension between trying to be impartial and trying, to examine what are the ethical obligations of the part of a mediator. I don't have ready answers, but I'm just throwing these special issues in practice. There will also be questions about when exactly should the mediator pull the plug, in the sense that when should the mediator end the mediation session? And in this regard, we can see how we can see the power that actually lies in the hands of the mediator. Because typically, when the mediator says, "I think we're not getting anywhere. I think that it's difficult for the parties to reach an agreement, and so I think we should just terminate the mediation session." Once the mediator reaches the point, it's likely going to be the case that the parties are going to walk away without having settled the dispute. Now, of course, it appears to be quite simple, but of course, there is actually a broader implication if a mediation session is ended, and that is, given the fact that the parties have failed to resolve their legal dispute, they're likely to then commence legal proceedings and go to court. And you can just imagine, therefore, the impact on the parties in terms of having to spend for legal costs, the emotional concern that they may have, and the hardship that they will have to undergo in having to go through court legal proceedings and so on. And so it is not an easy matter when a mediator makes a decision to end the mediation session, and what the mediator says is likely going to be followed by the parties. If the mediator says we need to end the session, it's likely going to be the case that the mediation will be ended. It will be very difficult for one of the parties to say, no, we should continue the mediation session, because in doing so, for example, in a sense, that will tip the hand of one of the parties in showing that that party is perhaps desperate to reach an agreement, and that can then be taken by one of the parties against him or her. So we see the power of the mediator in relation to mediation sessions. On the other hand, if we're dealing with one of the parties saying, I don't think this is going anywhere, we should just end the mediation session, the mediator can still say, okay, I understand how you feel, but I think we should keep going. I think we're making progress in the sense that you're communicating with each other. I know it can be frustrating, but if you want to avoid a protracted and very costly legal proceeding, I think, and for the interests of the children and so on, it may be worth our time to just spend a few more minutes, in trying to seek a common ground and reach an agreement and so on. And so therefore you see the power on the part of the mediator. When the mediator says, the session has to be ended, it's likely that the parties will have to abide by it or acquiesce to what the mediator says. On the other hand, if one of the parties says to end it, it's still possible for the mediator to influence the parties to continue negotiating with each other. Okay, now the ones that the issues that I raised earlier become more common when the parties are self-represented. When I say that the parties are self-represented, it means typically that they're representing themselves and they don't have access to a lawyer, or they don't have representation by a lawyer or solicitor. What this means then is that if there is a self-represented party, that party is unlikely to have any legal knowledge, no knowledge about the law, little knowledge about his rights, his legal interests, and so on. The party may be very unfamiliar with the legal process, what actually happens if the mediation proceedings are terminated and they have to go to court. And so the parties, as I mentioned also, the self-represented party also would be very unfamiliar with what to expect in a mediation proceeding. There's also the problem about best alternative to a negotiated agreement, as well as a worst alternative to a negotiated agreement. Because when you speak of BATNA and WATNA, and focusing, for example, on BATNA, the best alternative to a negotiated agreement, what we should bear in mind is that the best alternative to a negotiated agreement for a party is a position which is almost guaranteed by the law. So if a party is aware that if he or she goes to court, this is what he or she gets at a minimum, that's the best alternative to a negotiated agreement. And so therefore, the party then, in negotiating in the course of a mediation, would seek to get more in the course of the negotiations. The problem, though, is that the person is likely to know what the BATNA is, at least looking at contemplating it from the viewpoint of legal positions or legal rights. What it means is that the party must somehow be aware of his or her legal rights. But a party who is unrepresented, a party who doesn't know what the law is likely unable to properly articulate what his or her BATNA might be. So that's a problem. That is something that ought to be borne in mind. The other thing is that the problem with self-represented parties is that there can sometimes be uncertainty of a party's competence, whether or not there is legal capacity, whether there is informed consent. In other words, it may be possible that at that time that the mediation is conducted, there might be questions about whether or not a person might be, in a proper frame of mind, or whether or not a party actually has the legal authority to bind somebody else, which means that on the part of a company representative, there is the question that even if that representative tried to bind a company that he or she is representing, he or she may not have the legal authority to do so, and therefore the mediation session may, in a sense, be pointless and fruitless because that party will not be in a position to bind anyone. The other significance about having self-represented parties would be the question of, the lack of access to objective information and options. So, because in many cases, especially when a dispute becomes very emotional and heated, it's very possible that a disputant or the disputants may form very subjective, well, of course, they have to form very subjective views about reality or about the nature of the dispute. And this can, of course, happen to to us as well. And because we always interpret reality from the viewpoint of our own experiences, from the viewpoint of our own lenses about what reality is, the kind of reality that we see is often distorted and perhaps may lack a full picture of how things really are. And that then can lead to an inflation about what a person perceives to be right or to be just. And of course, there's an advantage in having an objective person who can be there, maybe in the form of a lawyer, who can provide advice not only about the law, but perhaps about the evidence or the nature of the dispute and so on. There again will also be questions about fairness, in the sense that if you have a situation where one of the parties has a solicitor or has consulted a solicitor, as opposed to another who really is very unfamiliar with the law, really very unfamiliar with his or her legal rights, it's quite clear that there is a disadvantage on the part of one of the parties there. There'll be questions as well about confusion about the mediation process, because the party participant may not know what to expect in a mediation session. And related to the issue about the lack of access to objective information will be questions about the factual and rational understanding of a situation, the ability to consider options, the impact of decisions, or make self-interested decisions can also come into play, in the sense that a person who is by himself or herself is not able to get independent advice, not only in terms of the law, but the fairness or the practicality of a negotiated agreement. And there might also be questions about the ability to conform behavior to mediation rules. And so for the mediator then, given the complicated context of having self-represented parties, one of the questions that the mediator will have to consider, and which is very much related to the questions about power issues that I raised earlier, will be, should the mediator try to give advice and assistance to the unrepresented party? And that raises the question, is it that contrary to their mandate to conduct a fair and impartial process? Now, wouldn't there be the danger that if a mediator tries to advise the parties, he or she might in effect be practicing law, when in fact they should merely be practicing dispute resolution, which means as far as dispute resolution is concerned, it's of course going beyond the legal interests of the parties and looking for an interest-based agreement or settlement. I also mentioned earlier the question about should a mediator, for example, allow a party to sign a potentially binding agreement when there might be doubts as to the extent of the party's knowledge and understanding of the legal implications. So, for example, in the Tapuhi's case, one of the parties was complaining that she was quite unfamiliar with taxation and accounting issues relating to the proposed agreement, and that party was thinking of seeking legal advice. And the question then is, as far as the mediator is concerned, should the mediator try to prevent the parties from reaching an agreement when they're both ready to sign an agreement, in order to then ask them to first, go seek legal advice? That can really be problematic, wouldn't it? You've got a situation where the parties are ready to sign an agreement, and then the mediator says, no, don't sign it yet, seek legal advice, which can mean that chances are, after getting legal advice, the parties may then be unlikely to reach agreement. That is that can present both ethical and legal issues, wouldn't it? There will also be questions on whether or not the mediator should mediate or not, or when to terminate a mediation when one of the parties is a self-represented party. Okay, so we've covered power issues, we've covered issues relating to self-represented parties. One of the other issues we should be considering will be mediation sessions where there are people not at the negotiating table. We know, for example, or we should know that even as individuals, no matter the decisions we make, the acts we do, we are often influenced by people, by family members, by friends, by third parties, and so on. And so therefore, in the course of negotiations, although you might see two individuals negotiating with each other, these individuals, when they make decisions, when they negotiate, are of course influenced by people who might not be there. They may have parents, they may have children, they might have relatives, friends who say, no, you should only do this. And yet, in the course of mediation, these persons are not going to be there. And so it can be a frustrating task then for the mediator to deal with the unseen presence of spouses, relatives, friends, neighbors, and well-meaning bush lawyers who have given the parties considerable advice and instructions before they reach the mediation. In other words, for those parties often, being who are part of a mediation process, they probably would have gotten advice somehow from well-meaning people. They might have gotten advice from lawyers who potentially could have gotten it wrong, or may have just focused on a limited aspect of the law without really looking at the broader picture of what is really to the best interest of the parties. And so in the course, therefore, of negotiations, in a sense, there are constraints in the ability of parties to reach an agreement because they are influenced by parties outside. There will also be questions of, one of the parties may be considered to have given up so much of the rights and therefore, end up having a loss of face in relation to family members or friends. And so it becomes a frustrating task for the mediator if the key people are absent, especially also in a business context, because in that scenario, if the representative of a company does not actually have the legal authority to bind a particular company, then the agreement will not have any effect in law because it won't become a binding agreement in the absence of consent from a person who is actually in a position to bind a particular company. Now, what are the options of mediators when the influencers are absent? Of course, the word influencer, I'm using the word influencer mainly because it's now more commonplace. Like, you've got Twitter influencers, perhaps Instagram influencers, and so on. So I use the word influencer to refer to people, third parties, not at the negotiating table, who often have a strong ability to influence the decision-making and actions of one of the disputants. So what are the options of mediators? The mediator can decide not to refuse to negotiate, in the sense that, or this could be an option as well for one of the parties. If an influencer who appears to be strongly influencing the position of one of the parties is not there in the first place, what's the point of mediating? Or what's the point of negotiating? The mediator can also adjourn, or one of the parties can ask for an adjournment of the session until an authority figure is present. The mediator can decide to just carry on regardless, just go on anyway. Not only because it may in fact be quite helpful for the parties to have a chance to talk, to communicate, even if there might not be any final outcome. So for those who, for example, are caught in a bitter dispute, the opportunity for them to meet face to face may be an important step by which they break the cycle of anger, the cycle of distrust, and so on, in the hands of a good mediator. The mediator can also normalize the situation, in the sense that it's often a given that the mediator or the parties really don't know who are the third parties who often have or hold a strong influence upon a particular party. It may be that the mediator can also insist on a written authority to settle, which is a quick formality to check anyway. The mediator can also suggest to the parties that they should agree to use best endeavors to solve the outcome to constituents. So even if the parties, even if the mediator is aware that the parties by themselves are unlikely to reach an agreement without having to consult a third party or an influencer, then in that case, it may be helpful for the parties to reach a provisional agreement, a conditional agreement, subject to them then taking best endeavors or best efforts to try to convince influencers to go on board with the proposed agreement. Another option may be for the mediator to suggest to the participants to consult with influencers before they even enter into a mediation and about the decision-making process, find out what their best alternative to a negotiated agreement might be, find out what their minimum legal positions might be, so that there is at least a point at which the mediator can try to get or coax the parties to try to reach an agreement. The mediator may also try to explain the settlement of progress to influencers, as well as warn of the dangers of reneging and failing to settle the dispute. Let the participants be aware that if they fail to reach a dispute, what then are their options? They're gonna have to go to court, which can be a very expensive process, not only in terms of money, but also in terms of time and effort and psychological costs. Now, so we've covered power issues, we've covered instances where there are self-represented parties. We've also just covered the question of what happens when there are influencers or third parties who are not at the negotiating table or not at the mediation session. We're not going to be looking at shuttle diplomacy. It can often happen that given the acrimony in a dispute, or given a scenario where one of the parties may not want to engage with another out of anger or maybe even out of fear, because that person, for example, has been subjected to domestic violence or family abuse, or is afraid of himself or herself. And it might even be possible that one of the parties is in hiding. And yet that party may be interested in really exploring the possibility of reaching agreement, but doesn't want to confront the other party. Then there is the possibility of having what is known as shuttle diplomacy. The notion, for example, of shuttle diplomacy mainly comes, for example, from international negotiations, where you can have states that have been at war. For example, it could be before. It could be Egypt and Israel, and the presidents of both states really can't face each other, because even the idea of them meeting each other might mean giving legitimacy to the other side. Like Egypt, for example, if it doesn't recognize before, if Egypt doesn't recognize Israel as a state, then certainly the Egyptian president cannot deal with the Israeli president, because to do so would be to give legitimacy to Israel as a state or as a nation. Or it might be that, you know, if there are negotiations, say, between the U.S. government and terrorists who might, you know, Al Qaeda or ISIS or whatever. Certainly, the U.S. government would not wish to directly deal with them. Maybe because in doing so, again, it might give legitimacy to the other side. And so it will be important for there to be a mediator. And what the mediator does then is to get involved in what's known as shuttle diplomacy. So the mediator, you know, shuttles between one party and another to try to get them to reach an agreement. It could be a formal affair that they're getting into. It could be something informal, which is out of the eyesight of the world. Now, going back to the question then of shuttle diplomacy in relation to alternative dispute resolution, and in particular in relation to mediation, shuttle diplomacy is also understood by the concepts of shuttle, mediation, or even caucusing, the practice by which the mediator speaks with some, but not all parties at the same time. So in that case, the parties are not there present to you know, face to face or to meet each other directly, and so the mediator just shuttles from one party to the next. It may also be used as part of a wider process, or the entire mediation may really be conducted in a shuttle mode. And we're going to be, and you know, again, in the context of domestic, where there might be evidence of domestic violence or history of domestic violence, this may be the most appropriate mode where there are fears of, you know, there are fears upon the life or security of one of the participants. Now, of course, even when we consider shuttle diplomacy, it doesn't have to mean that if you're using shuttle diplomacy, that's always the kind of option you're using, because it doesn't have to be either or. There are numerous variations. So in some instances, it can be shuttling between the parties, or in some instances, it may involve face-to-face meetings somehow, or it may involve the use of lawyers. In relation to shuttle diplomacy, it may also mean, and it's quite common, that given technology, you might have online mediation or online dispute resolution, which can involve shuttle diplomacy in the sense that you know, the parties can be meeting at the same time, perhaps in a Zoom session, and yet the parties are in different rooms. The parties don't really interact at the same time, but in that Zoom session, for example, the mediator can talk to one party and then talk to another, and so on. Now, as we will see, there are ethical questions and issues that will have to arise in relation to shuttle diplomacy, and we're going to be considering them shortly. Now, of course, for shuttle diplomacy to work, it's important that the parties must end up you know, having trust towards the mediator who conducts the shuttle diplomacy. Because if you have a mediator who might have a vested interest or who might be unscrupulous, it will be it will be an opportunity for a mediator maybe to withhold certain facts that ought to be given in full to another party. Or it might be that, you know, if a mediator somehow allows for some unconscious bias to seep into his actions, it may be that the mediator, you know, may try to play favorites with one of the parties. So in other words, if you have to talk to another person, you don't really know what the other person, the mediator, will then convey to the other party. So that's a problem with shuttle diplomacy. So there is it's important for the mediator then to try to build up trust between the parties. The mediator should also be clear about this commitment, to be scrupulously clear about the private nature of caucusing. This in particular means that if there is any attempt at shuttle diplomacy, for example, it should be very clear that any information that is conveyed is confidential, and only that information which another party allows to be conveyed will in fact be conveyed. It also requires a commitment from the mediator to seek clarification and confirmation at each stage of the process as to the exact issues and proposals that one party wants the mediator to convey to the other party. Now, what are the benefits? There are many benefits. It can be a useful device in processes or disputes where there are high emotions and or serious imbalances of power, such as in family mediations. It can be helpful when there are huge communication barriers, inter-party conflict, or the fear of losing face. Because rather than the parties not seeking mediation at all because they're unwilling to face each other, with shuttle diplomacy, at least the parties begin to talk or communicate at least through a third person or a neutral person. The shuttle diplomacy can be important as a way for the mediator to be able to screen for domestic violence and other forms of intimidation. As I mentioned, it can be a way to overcome communication barriers, especially in high conflict cases, a way to overcome emotional barriers, a way to overcome information barriers, especially where a party might be reluctant to give information in a joint session with in view of pending litigation. It can be a way to overcome cultural barriers in the sense that one of the parties may be unwilling to negotiate or deal with another party in dispute if that party, for example, is a woman or somebody who is much younger and so on. It can be a way to overcome strategic barriers such as the fear of revealing a bottom line. It can be a way to generate more options as parties are less inhibited, because if a mediator then conveys possible options, it may not be clear that it's necessarily coming from one of the parties, but may just be a creative way by which a mediator is offering possible solutions to the parties. There's also the advantage of shuttle diplomacy is that there's also less fear of losing face on the part of the party, mainly because it may not be so much a party giving up certain rights, but the party can argue that it was really upon the strong influence of the mediator, and it will also be a good way to start building a trust relationship with the mediator. Now, what are the concerns about shuttle diplomacy? There are a few concerns. One is that the mediator actually has too much power at the expense of the party. So the mediator already, as we know, there's already a power imbalance on the part of the mediator. We've covered that previously. But to give the mediator the power to actually be at the center where the parties are not meeting each other face to face, there's a lot of power on the part of the mediator, because at the end of the day, only the mediator knows what the parties are trying to convey. Only the mediator is actually in a position to make to understand what the emotional positions might be or the legal positions might be of the parties. And with that knowledge or information, the mediator is in a better position to influence or perhaps pressure the parties to reach an agreement. There's also the risk of manipulation by mediator. There's also the loss of opportunity to better understand each other's views. So the problem with shuttle diplomacy and where the parties are not there face to face is that their understanding of the positions of the other party is filtered through a mediator. There might be a loss of opportunity as well to improve the relationship. So yes, for example, when there is a history of domestic violence, of course, there are very strong reasons why one of the parties, especially if the person is a woman, might not want to come face to face with the tormentor, with the abuser. So that's understood. However, given the fact that sometimes, even if there is a negotiated agreement, or even if there is a consent order coming from a court, it's possible that the parties will need to try to enforce that agreement for several years. And so therefore, it is inevitable that the parties may really at some point have to learn to engage with each other. So if there is shuttle diplomacy, and even if the parties reach an agreement, they have lost an opportunity to try to use the mediation session as a way to communicate better, as a way to improve the relationship. I'm not saying that they ought to, but I'm saying that there is a loss of opportunity in doing so. And as I mentioned, it's a loss of opportunity to practice communicating with each other, which can be important even when there is a negotiated agreement between the parties. Now, so we're going to be talking now about gender issues. So in relation to the mediator, it's often the case that in certain cultures, and it might even happen in Australia or even in Western society, there is the perception that sometimes, men are better than women, women don't have the competence and so on. This isn't true, of course, but sometimes there is societal bias and we see the societal bias in what we know to be, glass ceilings for women. If you compare, for example, levels of position that women can aspire to or often reach, when you examine the median income for women, it is often the case that women often, do not get the share that they deserve. And it likely is the case that this is because of bias issues or gender issues against women. So that can be a problem when it is men, when it's a woman, for example, who is undertaking the mediation session. There might be an implicit bias on the part of a participant and so on. In some cultures as well, some male individuals do not want to deal with the women because they tend to view them as inferior. So of course we know this exists in some societies. And in particular, women may experience social and financial backlash when they behave assertively. So when you have a mediator, for example, as a woman, and that woman mediator tends to be quite assertive, some men who are participants may find this to be an uncomfortable situation for them, especially if they're not used to engaging with women who appear to have authority or power in a particular proceeding. Now, for the parties, again, men may have the wrong view that they have a higher status, or that that they are superior to women. It might be the case that men may gain greater negotiation outcomes, mainly because men may tend to be, to be assertive, may even be quite aggressive in pushing their agendas, as opposed to women who because perhaps of cultural issues or societal expectations, may tend to be less aggressive or assertive in their assertion of legal rights. And of course, women may experience social and financial backlash when they begin to behave assertively. It's kind of like it's unfeminine and so on. This is wrong, but I mean, this exists. These kinds of biases, implicit and both explicit, still happen in society. And it's often the case that it is easier for men to balance the simultaneous needs to compete and cooperate in negotiations. And so for these reasons, a mediator should be aware about gender issues in relation to mediation sessions. There's, of course, the broader problem of possible domestic violence. There's a caution, of course, against requiring a woman who has been the victim of domestic violence to attend a dispute resolution process with the former abuser. I mean, if a woman has previously experienced domestic violence, it's almost like forcing a woman to revisit a history or experience of domestic violence. And as we know, that's something that is acceptable. Now, of course, although I focus on the woman as a victim of domestic violence, it is of course true that there have been men who have also been victims of domestic violence in the hands of women, except that the statistics show that in a disproportionate number of cases, it is women who often are the victims of domestic violence. And when women are exposed to or subjected to domestic violence, the impact upon them is, of course, greater, whether it's in the form of emotional or physical harm. Now, on the other hand, there are those who argue that yes, women who have been victims of domestic violence probably shouldn't participate in a mediation session where the other party is there, but some would think that it can also be empowering for a woman to actually meet an abuser face to face, because it might be a signal that the woman has moved on, that the woman is strong, that the woman is independent. And there are valid points in this. If then the other party can see, the other my ex-wife, for example, is now a different person. This is now a woman who's come out of her shell, and a woman who is now strong and assertive. And of course, a lot of it has to do with how a mediation session is conducted by a mediator, because there are concerns about security and risk. So, and we now go to the question about whether or not, this is the final issue we're considering, whether or not a mediator should decide to mediate or not. Under the Australian National Mediator Standards concerning power issues, it provides that some disputes may not be appropriate for mediation processes because of power imbalance, safety, control, and/or intimidation issues. If at any time abuse is present or implied or threatened, the mediator should take appropriate measures to ensure the safety of participants, such as by activating appropriate predetermined security protocols, using video conferencing or other personal protective and screening arrangements, requiring separate sessions with the participants, enabling a friend, representative, advocate, or legal representative to attend the mediation sessions, referring the participants to appropriate resources, and suspending or terminating the mediation session with appropriate steps to protect the safety of the participants. Under the Australian Family Law Act and regulations, if there's also a requirement that a registered family dispute resolution practitioner under Regulation 25 must be satisfied that consideration has been given to whether the ability of any party to negotiate freely in the dispute is affected by any of the following matters, such as a history of violence, if any, family violence, if any, among the parties, the likely safety of the parties, the equality of bargaining power among the parties, the risk that child may suffer abuse, the emotional, psychological, and physical health of the parties, and any other relevant matter that the dispute resolution practitioner considers relevant. And under Regulation 25, subsection 4, it states that where a family dispute resolution practitioner is not satisfied that family dispute resolution is appropriate, then the family dispute resolution practitioner must not provide family dispute resolution. And so, with that, on completing this topic, you should then be able to discuss and explain the issues in relation to mediation sessions that relate to power, self-represented parties, people not at the negotiating table, shallow processes, gender, and not deciding not to mediate. And just as a reminder before you go, if you could, please try to answer the Have You Say survey. And with that, thanks for watching this video. Thank you. Bye.